Hi guys, in this video I'll be discussing language and the law, starting off with discussion of Scalia, also a famous case from a paper by Hart, No Vehicles in the Park, and then lastly I'll discuss very briefly the contrast between Scalia's view and Justice Ruth Bader Ginsburg's view on interpretation and the text versus intentions. And then at the end we have two videos. One is of Scalia speaking with Ginsburg in an interview, and then we'll have one that's just Ginsburg being interviewed on her own. So throughout this semester, throughout the class, we've been asking this question: where does meaning come from? If we look at a word or a phrase or an utterance or even a gesture, we can ask, what does that mean and where does that come from? With linguistic utterances or written words, we can ask, does it come from the words themselves or from something else? These are some cases that we've seen. The first one is raining. We've spoken about that one quite a bit. I spoke about it in a video. We also spoke about it on the very first day of class. There's this question, what does "it's raining" mean? First of all, we need to understand what raining is. There's not a clear line out there in the world, whether or not, if it's raining or not. We can imagine a law that said no rollerblading if it's raining. That could be difficult to apply because there are ambiguous cases where there's a certain amount of precipitation coming from the sky. It's not clear if that counts as raining. What if it's snowing, and so on. Also, "it's raining" doesn't include a particular location. We infer that somehow, but it's not in the phrase "it's raining" itself. It's not within the words themselves. We also have talked about metaphors and non-literal speech. We have things like "he's a hammer" or "like a whisper." The law tries to stay away from these types of phrases, right? There's a reason that laws are written in a very dry, lengthy, maybe overly explicit way, is because people write laws, they are trying to be as clear as possible. So the law wouldn't have things like metaphor or more figurative speech because we know that, of course, that would be very, very difficult to interpret. If there was a law that you can't walk down the street like a hammer, how are we going to interpret that? So we know that there are these issues with language and meaning broadly. Laws are written in language, right? There's a metaphysical question about, what really is the law? And maybe the law isn't the same as those words, but the law is certainly transmitted in those laws. It's in those words. It's passed down to us in those words. And lawyers and judges deal with the written word as law. So that means that all of these issues of ambiguity, how do we interpret certain things, maybe it's context, maybe it's intention, maybe there's something about the words themselves, all of these issues come to the fore with law. And the meanings of laws can literally be a matter of life and death. With Juliet is the sun, less hangs on that. But with laws, we really need to know, what does this mean? Did this person commit a crime that will lead them to have the death penalty? Should this person be put in jail for the rest of their life? So we have a couple of options. Do we insist the laws themselves have meaning? This is the approach that Justice Scalia takes and that you read in his piece for the worksheet on Monday. Or, on the flip side, is the job of judges to work out the intent of the legislature. This is the view that Scalia attacks in his piece, and we'll see a video from Justice Ruth Bader Ginsburg, arguing for this approach. Either approach has its problems. I think that the problems with the Scalia view come up pretty clearly in his piece, with the case of the use of a firearm. The problem with focusing on the intent of the legislature is it's often difficult to work out. Or maybe it doesn't even matter exactly what their intent was. But when working out somebody's intention is difficult enough if it's just one speaker standing in front of us. We've talked about mind reading, how we're able to do that. It's very difficult to think about what an intention of a whole body could be. Does that even make sense anymore? If it's 200 people voting, is there an intent, or are there 200 different intents? Okay, so these are some of the pieces of law that were in the reading and that you did on the worksheet. No vehicles in the park. I asked you how you could exploit the ambiguity in the first one to help defend a client. You guys did a good job with that. Some of you talked about vehicles. Some of you talked about the park. In the park, does a parking lot count? And then use of a firearm. This is one that Justice Scalia mentions and discusses. There's also, so in the reader, there was the Supreme Court ruling about this case. So if you're interested in this, if you're thinking of writing your final paper on this topic, you can go back in the reader and read the actual law, read what the Supreme Court ruling was, and read Scalia's dissent. So Scalia said Smith did not use the firearm, because to use it is to use it in a particular way. It looks like from the worksheet that most of you guys did agree with Scalia. So you're saying things like, yes, entirely, it is absolutely silly to tack an extra charge on someone who's clearly a victim in the situation. I agree. Yes, the gun was used as a means of payment. Also, his analogy with a cane gets the same point across. I agree that to use a firearm is to employ it as a weapon. I disagree with that. So I know I've told you guys already that I understand meaning in terms of intentions. That, of course, doesn't mean that you have to agree with me or feel like you have to write your paper in such a way that you agree with me. To me, it seems clear that that isn't a part of the word use itself. I feel like if the purpose was to say fire the firearm, or firing a firearm is what is bad about using a firearm in a drug transaction, then this word here should have been fire rather than use. I think having a gun, present at a crime escalates the situation. So although nobody fired it, its mere presence makes it much worse than if the gun weren't there. And I personally disagree with Scalia. And that's because I don't really think it's in the meaning of the word use. So do you agree or disagree? Most of you agreed, as I said. A few of you disagree. So one of you wrote, if the gun had nothing to do with the drug sale, it was just on the man's side, then I would agree with Scalia. Since it was directly involved in the crime, Smith did use the gun. This person also writes, additionally, the word use, is a much broader word than Scalia says. There's another person who disagrees. You said, I disagree with Scalia's conclusion that Smith did not use the gun because Smith intended for the gun to have a purpose. I think it would be different if Smith had just been in possession of the gun, like if he hadn't tried to trade it but was found to be in possession of it later. But the fact that he tried to exchange it for something else implies some active degree of choice. But there are just a few here. So most of you were persuaded by Justice Scalia's argument, but in the ruling, most of the justices said that they disagreed with Scalia. Scalia was the dissenting view in this case. So again, that is in the course reader, and you can go and take a look at that if you'd like. So Justice Ginsburg disagrees with Scalia about meaning and intent in the law overall. I didn't assign something from her, and rather than do that, I have a couple videos here that we're going to watch.
In the couple of minutes that we have left, I want to just ask a question. You've both been great buddies for a long time now, but when did you meet and what were the circumstances, if you could?
I bet he doesn't know.
Huh?
Go ahead, Ruth. Go on.
When did you meet?
Well, we were buddies on the D.C. Circuit.
DC Circuit, right.
But
And that is when you met at that time?
I met Nino for the first time when he was giving a speech to some unit of the ABA. It must have been the administrative law section.
Ed law section, probably, yeah.
And it was on a case that had recently been decided by the D.C. Circuit. It was before either of us got there. And it was about...
We were both academics.
it was about the Vermont Yankee case. And you were inveighing against it.
Terrible.
And I was listening to him and disagreeing with a good part of what he said, but thought he said it in an absolutely captivating way.
I think we should leave it at that very point. I mean, as you know, composer Derek Wang, who is with us tonight, has produced this opera called Scalia Ginsburg, and in it, to beautiful music, you're both locked in a room, I understand, unable to get out unless you agree on a compromise consistent with the Constitution. And at one point, Scalia roars in despair, "Oh, Ruth, can you read? You're aware of the text, yet so proudly you have failed to derive its true meaning. The Constitution says absolutely nothing about this." To which Ginsburg replies, "How many times must I tell you, dear Mr. Justice Scalia, you are searching in vain for a bright-line solution? But the beautiful thing about our Constitution is that, like our society, it can evolve." So we've got only about a minute or so left. Are you two ever going to agree on big issues and still maintain the friendship?
We agree on a whole lot of stuff.
You do.
Ruth is really bad only on the knee-jerk stuff. She's a really good textualist, in those things where the text is what she's guided by. She's terrific. She's obviously very smart. And, most cases, I think, we're together.
But I
think we're together. We're together in a lot of criminal defense cases, upholding the rights of the criminal defendant. Ruth and I are quite frequently in dissent from the court's decision. So no, we agree on a whole lot. You have it wrong.
I keep seeing these 5-4 decisions where you're on one side and she's on the other.
That's because the press focuses on the 25% of the heady cases, the constitutional cases. Most of what we're doing is trying to interpret dense statutes that Congress passed that are very difficult to parse. And on those cases, there isn't the usual lineup that the press expects to see in the most watched cases. So we agree on many procedure cases, not always. You got one wrong last year. but
Well,
and also I have to say something else. We both care about the way opinions are crafted. I mean, it's not easy to write an opinion. And I think you care very much about how it's said, and so do I. Of course, the way we say it is quite quite different.
Different.
And one
I-
reason we became such good friends on the D.C. circuit was that we were both former academics. I guess Harry Edwards was another academic on the court. But in academia, at a law school, when you wrote a law review article, you would circulate it to your colleagues, and they would make comments, helpful comments, not just, this is wrong, but there's an additional point you could make. Well, Ruth and I did that with one another's opinions. We wouldn't do it to anybody else's, but she'd suggest some additional stuff that I could put in, and I would for her as well. And that's
I
where
would
it
like
started.
us to go on, but our time's up, and I'm sorry about that. I want to thank our wonderful, attentive audience. I want to thank the many who watched and listened all over the nation and the world, but most
was imposed upon the states that we began to have them. And so a lot of the restrictions on speech that that would be imposed by states would not have been thought to violate our Bill of Rights, maybe the state's Bill of Rights, but not ours.
But I'm wondering, at the time that the structure of government was set up, plus 200 years ago, what is it that the Founding Fathers had in mind when they thought about freedom? And one definition advanced by John Stuart Mill I found very compelling, but I don't know whether that's what they had in mind. He spoke about absolute freedom of opinion and sentiment on all subjects, practical or speculative, scientific, moral, or theological. And I'm wondering if that is what Madison Monroe had in mind at that time, or whether they had a more narrow vision of freedom. Justice Ginsburg?
I wouldn't call the vision narrow, but there are no absolute rights. Even though, if you read the First Amendment, it does sound that way. It says Congress shall pass no law.
No law.
But of course, there are laws that Congress can pass. So the idea of an absolute right, I don't know any right that doesn't have limitations.
Even at that time, in the minds of the Founding
Yes,
Fathers.
I think so.
Explain why, in the First Amendment, after listing the phrase freedom of speech, the Founding Fathers found it necessary or wanted to add 4 crucially important words, or of the press. Freedom of the press is what they were talking about. But why did they add that phrase? Why was it necessary, Justice Scalia?
I think it's a natural addition. All it means is the freedom to speak and to write. It wasn't referring to the institutional press, the guys that run around with a fedora hat with a sticker in it that says press. That was, I'm not sure that they even referred to the institutional press in those days. It meant the freedom to speak and to publish. And that clause has been interpreted not to give any special prerogatives to the institutional press. It gives prerogatives to anybody who has a Xerox machine.
What do you mean institutional press? Forgive me. What does that mean?
I mean those organizations whose business is writing and publishing. NBC, CBS, you.
I like that.
One idea that we didn't take from England was the office of the censor, who censored books before they were published. And that, I think, is part of putting in this protection of the press. And we have never had, in the United States government, an office of the censor, which plagued people in England and on the continent. Think of Verdi and having to put his opera plots.
Oh, you have to bring opera into it, don't you? I knew you were going to do that.
Was it understood that there were limitations on the press back then? Was it understood that there were limitations?
Well, yes, on speech and on oral speech and written speech, both. I told you, libel laws were one thing.
Yes, but what about the press at that time? What were they thinking about at that time?
I don't know that there were any special rules applicable to the press. The press did not have to get permission of a censor to publish.
Okay.
but neither did anybody else.
And the press annoyed us. Some very important figures in our history, like Thomas Jefferson.
Yes, indeed. And it's interesting that Jefferson, before he became president, spoke very highly of the press, but while he was president, spoke about it as a polluted area. And you couldn't believe a thing in any newspaper.
But how it survived, one thing that epitomizes for me the importance of freedom of speech is in the Ballad for America. The right to speak my mind out, that's America to me.
Yeah, I think if you had to pick, and you probably shouldn't have to, but if you had to pick one freedom that was that is the most essential to the functioning of a democracy, it has to be freedom of speech, because democracy means persuading one another and then ultimately voting, and the majority rules. You can't run such a system if there is muzzling of one point of view. So it's a fundamental freedom in a democracy, but much more necessary in a democracy than in any other system of government. I guess you can run an effective monarchy without freedom of speech. I don't think you can run an effective democracy without it.
But on this matter of press freedom, John Adams wrote that mankind.
And now here's a clip from many years earlier at Justice Ginsburg's confirmation hearings in 1993. One of the pieces of law that she will discuss is all men are created equal. And we can ask, does this include women too? Is this in the words themselves?
As a matter of fact, Dred Scott was the first illustration of substantive due process, where the judges just decided they wanted it done this way. Justice Taney thought he was really saving the country through doing that, so he did that, which really was not ahead of society. Society, at least in the North, was ahead of him. And in the case of Brown versus Board of Education, Mr. Justice Harlan in 1896 said that separate but equal was wrong. And so, in all honesty, the court was not ahead of society, but society really was ready for that type of a decision. Now, there are many criticized Brown versus Board of Education for the rationale of the decision, but frankly, all Brown versus Board of Education did was what Justice Harlan suggested, and that is treat equality as equality, and under the 14th Amendment. So it isn't a question of whether you're ahead of society or not, it's a question of whether you're actually interpreting the laws in accordance with the original meaning, which of course, under the 14th Amendment meant equal protection, equal rights, equality. But let me just move on to something else. I would like to ask you whether you agree with the following statements about the role of a judge, including a Supreme Court justice. The first statement is this: the judge's authority derives entirely from the fact that he or she is applying the law, not his or her personal values. Do you agree? Do you agree or disagree with that?
No judge is appointed to apply his or her personal values, but a judge will apply the values that come from the Constitution, its history, its structure, the history of our country, the traditions of our people.
I agree. Then you agree with that basic statement, then. You shouldn't be applying your own personal values.
I think I made a statement quoting Holmes to that effect
You did.
in my opening remarks.
You did. What about this statement? The only legitimate way for a judge to go about finding the law is by attempting to discern what those who made the law intended.
I think all people could agree with that, but as I tried to say in response to the chairman's question, knowing what people trying to divine what the framers long dead intended, at least I have to look at that two ways. One is what they might have intended immediately for their day, and one is their larger expectation that the Constitution was meant to govern not for the passing hour, but for the expanding future. And I know no better illustration of that than to take the great man who wrote the Declaration of Independence, who also said, "For our state of pure democracy, there would still be excluded from our deliberations women who, to prevent deprivation of morals and ambiguity of issues, should not mix promiscuously in gatherings of men." Now, I do believe that Thomas Jefferson, were he alive today, would say that women are equal citizens.
Or else he wouldn't be president.
But what
think he
was
would,
his understanding of all men are created equal for his day and for his time? It was that the breasts of women were not made for political convulsion. So I see an immediate intent about how an ideal is going to be recognized at a given time and place, but a larger aspiration as society improves. I think the framers were intending to create a more perfect union that would become ever more perfect over time.
I think that's a good way of putting it. I think reasonable jurists can disagree about what the original meaning of a provision is or how to apply it under certain circumstances. I don't think there's any question about that, or as to how to apply it to a given set of facts. But so long as the judge's or justice's starting point is the original meaning of the text, then it seems to me that judge is seeking to fulfill his or her constitutional duty. But let me ask you about this statement. If a judge abandons the intention of the lawmakers as his or her guide, there is no law available to the judge, and the judge begins to legislate a social agenda for the American people. That goes well beyond his or her legitimate power.
The judge has a law, whether it's a statute that Congress passes or our highest law, the Constitution, to construe, to interpret, and must try to be faithful to the provision. But it's no secret that some of these provisions are not self-defining.
Right.
Some of the laws that you write are not self-defining. There's nothing a judge would like better than to be able to look at a text and say, this text is clear and certain. I do not have to go beyond it to comprehend its meaning. But often that is not the case. And so a judge must do more than read the specific words. The judge will read on to see what else is in the law, and read back to see what was there earlier. The judge will look at precedent. How are the words in this provision or in a similar provision construed? So the effort is always to relate to the intent of the lawgiver, the lawmaker. But sometimes that intent is obscure.
I like your statement that the judge has an obligation to be faithful to the provisions of the law.
So more broadly, we can sort of zoom back from this particular debate and look at this broader one. Are laws fixed, or should they evolve with our country? So this is almost above the interpretive question itself. It bears on the interpretive question. You might have a particular theory of interpretation, because that means that laws can change, or because that means that laws are fixed. So this ultimately, when Scalia and Ginsburg are talking about how they can interpret the text, in a way, they're also addressing this